Welcome, everybody, to the webinar on how Trump's illegal executive order on elections could impact how we vote here in Texas. This is presented both by the League of Women Voters Collin County, the League of Women Voters of the state of Texas, and our partner, the Texas Civil Rights Project. Before we start, I do want to say that the League of Women Voters is a nonpartisan organization. We do not support candidates or political parties. We focus mostly on issues that matter to our communities, ensuring fair elections, protecting voting rights, and strengthening our democratic institutions. And with that, we are focused tonight on election law. And before we start, if you would like to see Carl while we're looking at the presentation, you can put that in speaker view in Zoom. Also, if you have a question, you'll notice that everybody's on mute. If you could put it in the Q&A tab, and we will, depending on how the time goes, I'll be watching those, and I can ask Carl the questions, and we'll type the answers in there. All right, with that, let's get started. Carl is, you want to go to the next slide, Carl? Yeah. Carl Blair is our senior election protection attorney, and he's based in Sugar Land, but he's originally from Arlington in North Texas. And he's been working closely with us on what was happening in both Collin County and Williamson County with the move to hand-marked ballots. He has been very knowledgeable on election law. And so we are extremely happy that Carl agreed to do this webinar. This webinar will be recorded, and you'll be able to see it again on the TCRP's YouTube site. Plus, it'll be available on the League of Women Voters Collin County, Texas site, and I'm sure in other areas. With that, I'm going to turn it over to Carl.
Thanks so much, Liz. Hi, everybody. Yeah, like Liz said, I'm TCRP Senior Election Protection Attorney. And I will apologize. We're having thunderstorms roll through Sugar Land right now, so apologies for any thunder you might hear in the background. But happy to be here and really happy to get this opportunity to talk about this executive order and kind of how it could affect our fellow Texas voters in the future. So I like to start every presentation with just an outline, just to kind of give everybody a roadmap of what we're going to be talking about tonight, what topics we'll be covering. So first, we're going to go into a little bit of background. Why are we talking about this executive order? What's important about this order? What got us to this point? So we're going to talk about state and congressional authority over elections, and we're also going to talk about, in a more general sense, what is an executive order? We hear the Trump administration talking about issuing executive orders all the time, practically. So, what are they? What are their limits? What can they do? Then we're going to cover two specific areas of the executive order from March. The first is documentary proof of citizenship. And I know many of y'all are probably familiar with that concept from the recent legislative session down here in Texas. But we'll go into a little bit more detail about what this executive order specifically where it's trying to implement DPOC. And we're going to talk about the potential impacts that any of those changes might have on Texas voters. And then we're going to talk about another major portion of this executive order that I personally feel hasn't been getting quite as much attention because it's kind of a really technical area. And that's the issue of voting machine certification. So we'll talk about what this executive order is trying to do. We'll go over a little bit about what the voting machine certification process looks like. And then, the potential impacts those changes might have on Texas voters. And then we'll kind of wrap up our discussion with just a talk about the current legal challenges to the executive order, which, the League of Women Voters is a plaintiff in one of the cases that we'll talk about in that portion of our presentation. So all right, yeah, with that, let's go ahead and get started and jump into the background. So on March 25th of this year, President Trump issued an executive order entitled Preserving and Protecting the Integrity of American Elections. right? So this is the executive order that we'll be talking about this entire presentation. So anytime you hear me say executive order or the executive order, we're talking about this specific executive order. So jump forward a couple of months to June. So, just about 2 months ago, as Liz briefly mentioned, both Collin County and Williamson County, their commissioners' courts voted to change voting machines and switch to hand-marked ballots for upcoming elections. And officials in both counties were specifically citing this executive order as a primary reason for making these changes. And then ongoing, several lawsuits have been filed in federal courts challenging multiple provisions of this executive order, and several of the provisions have already been enjoined. So we'll get to that, obviously, when we talk about the legal challenges section towards the end of this presentation. All right, so let's jump into like who has authority over elections in the United States. So great place to start on these type of questions is the Constitution, of course. And fortunately for us, there is a very, very clear-cut place to start, and that's the Elections Clause. So this is in Article 1, Section 4, Clause 1. And for those of you who may not know, Article 1 deals with Congress. It talks about Congress's authority, Congress's powers. So I'm just going to read this verbatim for you. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time, by law, make or alter such regulations, except as to the places of choosing senators. So this is where we see, the authority for, and we'll talk about this a little bit more, but 30,000-foot view, this is where we have the authority for federal elections. Remember, these are for Senate, U.S. senators and U.S. representatives. The state legislators have authority over those type of elections, but Congress, specifically for federal elections, can also make laws that alter state regulations. You'll also notice one thing that I'm going to keep mentioning throughout this presentation. The president is not mentioned anywhere in this clause, right? This is Congress and state legislators. So let's dive a little bit deeper into what that authority how that plays out in real life, right? So states, and this whether it's Texas, California, any state, all states in the U.S. have the authority to enact laws that set procedural regulations on how elections are administered in their jurisdiction. So some really, really clear examples of that are voter registration procedures or requirements for certifying voting machines, right? So as we all know, in Texas, the Secretary of State is our chief elections officer. They are a non-elected official. They are appointed by the governor, and their main roles are to provide assistance and guidance to local election officials on the actual administration of elections. But they can also implement rules via the rulemaking process regarding how elections are administered in Texas. So that's how states in general, what authority states in general have, but also how that authority kind of plays out at the state level here in Texas. So switching over to Congress, Congress can preempt state laws that impact federal elections, and they can set new requirements for states to follow when they administer federal elections. And so an example of this that's going to be very important throughout this presentation is the Help America Vote Act, or HAVA. So this was a law that was passed back in 2002. It had a ton of requirements and modifications to state requirements. But the things that are most relevant for our presentation tonight are that states have to provide an option for provisional ballots and at least one accessible voting machine per polling place. States have to keep a centralized database of voter registration records, and states are now required to update and upgrade their voting equipment. Something that's also going to be very, very vital, especially when we get to the section on voting machine certification, is that HAVA also created the Election Assistance Commission, or the EAC. And the EAC is a bipartisan, independent federal agency whose sole purpose is to provide assistance to states in administering elections. And throughout this presentation, we'll kind of see we'll kind of see a few areas where the EAC has this authority, where they have this, ability to provide that assistance. All right, so let's shift over from, the authority over elections to executive orders. So baseline question, right? First thing we want to ask, what exactly is an executive order? Well, it's an official directive from the president that manages the operations of the federal government, right? So what's absolutely crucial to know is that executive orders, they instruct federal government agencies and departments on how to implement a bill that's passed by Congress, but they are not legislation themselves, right? And since that's the case, they also cannot override or preempt federal laws or statutes. Uh, and also, importantly, they can be challenged in court, as we'll see later in this presentation. They can be overridden by an act of Congress, or, and this frequently happens. We saw this happen when President Trump took office. Um, Executive orders that are passed by one president or issued by one president can be rescinded when another president takes office. We saw that when President Trump rescinded literally hundreds of executive orders that President Biden had issued during his time in office. But really, the major takeaway here is that executive orders can't override or preempt federal laws or statutes. If you only take one thing from this slide, that's what I want you to focus on. All right, so now let's actually get into some of the nitty gritty about this particular executive order, right? What is it asking? What is it demanding states and federal agencies do? So, like I mentioned, we're going to talk about two major sections and provisions of this executive order. And the first are the provisions that are dealing with documentary proof of citizenship, or DPOC. So, what is DPOC? DPOC refers to requirements that individuals provide documentary proof of their U.S. citizenship in addition to completing a voter registration form. So, we had Senate Bill 16, which was brought up at the state level, just over this past regular session. And it was very similar to this. It was a state level DPOC bill. So when we talk about documentary proof, the most frequent examples that are given would be a U.S. passport or a birth certificate. Now we all know the facts that a large percentage of Americans do not have a U.S. passport. However, there's also a large percentage that don't have birth certificates. We also see that many states like Texas have put in a lot of requirements, documentary requirements to even get a birth certificate. You have to have other documentation to get a birth certificate. So a major problem with DPOC in general is that you have a large percentage of our fellow American citizens who don't have access to any of this documentary proof of their citizenship. All right, so from that 30,000-foot view, let's narrow down a little bit to what exactly the executive order says about documentary proof of citizenship. Right, so it has.
Hey, Carl, we have a question.
Absolutely.
Is there any state that has documentary proof right now and of citizenship, and do you know how it's going for them?
I believe, don't like quote me on this, but I believe that Arizona does. I'm pretty sure that they were one of the first states that actually implemented a form of it. I think it's a little bit different than what was being proposed in SB 16. To my understanding, one of the major problems that they have in Arizona is that they have what's known as a bifurcated system. So they have people who are able to register just for federal elections, and that's because there's no DPOC required at the federal level, right? But then they have so some of those folks can only vote in federal elections, whereas some people can vote in state and federal elections. So that has caused major issues there. I believe that there are 2 or 3 other states that have like a full type of DPOC program or system set up at the state level. But so the major problem, like I said, is that an equity issue. You do have large percentages of people who don't have access to that documentary citizenship. But then on an election administration level, you have these situations where they have to keep multiple different registers of who's registered to vote, who's registered in only federal elections, who's registered in state and federal elections. And then just the difficulty in administering elections at that sense, making sure that the correct ballots are given to the correct voters, so it causes a lot of problems, basically in whatever form it's been tried in. And I like I said, I think that Arizona is I hesitate to use the word leader in this sense, but they are the state that's had the most long-standing DPOC program in place. So hopefully that answered your question, Liz.
All right, thanks.
Yeah, no problem. But yeah, so jumping back into the executive order, it's got four different sections that we're gonna talk about tonight. Section 2A1 demands that the EAC update what's known as the National Male Voter Registration Form to implement DPOC requirements. Another section demands that the head of every federal voter registration agency under the National Voter Registration Act, or the NVRA, verify citizenship prior to providing a federal voter registration form to anybody who's enrolling in any type of public assistance program. What's particularly pernicious about this is that it completely flips that requirement on its head. Because as it stands right now, um, these voter registration agencies, when somebody goes in to apply for public assistance, they'd say they want to register to vote as well. They will go ahead and hand out. Their default is to hand out the voter registration form, let the applicant fill it out, turn it in, and then they'll verify citizenship. This, of course, kind of flips that on its head by saying, no, until you verify citizenship, we're not even going to give you the form to fill out. So that's a major change that is one of those that kind of flies under the radar, I think. Another section is demanding that the Secretary of Defense update the federal postcard application to require DPOC. The FPCA, or Federal Postcard Application, is something that is used by service members who are serving abroad, and also U.S. citizens who live overseas. So that's also something that's very important as well. And then the last section that really touches on DPOC in the executive order is demanding that the EAC withhold all federal election funding to states that don't follow these requirements that are set out in the executive order. So kind of commandeering, kind of, extorting the states to, if you don't follow this order, we're going to withdraw all the funds, all federal election funding. So let's get a little bit more in depth into these sections. So, I mentioned the federal voter registration form, also called the National Male Voter Registration Form. Though those two terms mean the same thing. But it's a standardized form that U.S. citizens can use to register to vote in federal elections, and they can also update their existing voter registration details. So, name, address, or if you're living in a state that requires a political party affiliation, we don't in Texas, but states that have a political party affiliation requirement, voters can use this federal voter registration form to update that information as well. And what's so important about this is that under the NVRA, all states are required to accept this form for federal elections, right? And so Section 9 of the NVRA, it allows this form to request only the information necessary to assess eligibility, right? So that includes a citizenship checkbox and a signed attestation under penalty of perjury. So it's just going to be a checkbox that says I am a U.S. citizen, and then you're going to sign it under, saying that I'm not lying about this. I understand that there are penalties if I falsely misstate anything on this application. It doesn't require that extra step, of providing some documentary proof of your citizenship, right? And DPOC, of course, flips that idea and puts yet another burden, another hurdle in front of people who are trying to register to vote. All right, so let's talk about something called UOCAVA as well. So this is the Uniformed and Overseas Citizens Absentee Voting Act. It's a very long name, so that's why everybody calls it UOCAVA. But it's a federal law that allows certain U.S. citizens to register and vote absentee or by mail in federal elections. And so this is where we're talking about active duty members of the U.S. Uniformed Services. So that's Army, Navy, Air Force, Marine Corps, Coast Guard, Merchant Marine, the Public Health Service. NOAA has uniformed service members as well. And as I mentioned briefly in passing, U.S. citizens who live overseas. So these are the voters who use that federal postcard application that I mentioned a couple of slides ago to both register and request absentee ballots. So the FPCA has both of those. You can register to vote using an FPCA, and that's also the method that you would use to request absentee ballots. So any changes that are made to the FPCA have an immediate impact on U.S. citizens living overseas, but also active members of our armed forces as well. So what specifically does the executive order say about UOCAVA voters in particular? So it's specifically targeting military and overseas voters by demanding that the FPCA explicitly include a DPOC requirement. So what would this mean in practice? This would mean that military and overseas voters would have to submit citizenship documents every single time they register or request a ballot, right? And that's because, again, the FPCA covers those two categories. It covers the registration and anytime you're requesting a ballot. So if DPOC were required on the FPCA forms, like the executive order is demanding, every time a military voter overseas needs to request a ballot, they're going to have to resubmit their citizenship documents. And you'll see a resource link at that page if you are interested in learning a little bit more about UOCAVA and some of the ins and outs of that legislation. That link is for the Federal Voting Assistance Program. It is a government-run agency, and they help assist. Their job is to help assist military and overseas voters, following UOCAVA's instructions, getting the FPCAs out, all of that. So yeah, if you're ever interested in that, how that works, that is the link for the Texas specific chapter that they discuss on the FVAP website. All right. So remember, I also mentioned that another demand that the executive order is making would impact public assistance-based voter registration. So let's take a step back and look at NVRA requirements, the National Voter Registration Act requirements. So currently, the NVRA requires public assistance agencies to offer voter registration, right? And this is, during applications, no documentary proof of citizenship required upfront. And so what's very important, and this is a really, really broad requirement. This is any agencies that are dealing with Medicaid or Medicare recipients, where they would apply for that. SNAP benefits, WIC benefits, and also huge number state disability programs as well. So any agency that is, and there's many more, but these would be the biggest, some of the biggest agencies impacted by this demand. So, and that obviously covers everybody. That covers people in all 50 states. So this would be a very huge number of people who would be impacted by this particular demand in the executive order. So as I mentioned, the executive order just completely reverses that process. That turns a guaranteed access point into a conditional document-based barrier, right? So, person goes in to their state disability office to, start that application process. They want to register to vote. Previously, they would have just been given the registration. Then any verification would have been done after that registration is completed. Again, the executive order wants to flip that on its head and say, no, you aren't even going to be allowed to have a registration application given to you until you provide that proof of citizenship up front. So yeah, so we see a really big access point just turned into just yet another hurdle or barrier for voters, or potential voters in this case, to have to overcome. So let's narrow that down from, nationwide, kind of narrowing our focus again. So what are some of the specific on the ground impacts that we could see here in Texas, right? So in Texas, voters can still register using the National Voter Registration Form without submitting DPOC, without submitting any documentary proof of citizenship. They can still register public assistance offices through the self-attestation of citizenship. That's checking the box and signing the attestation. And then obviously military voters and overseas voters who are registered here in Texas can use the FPCA forms to register and request mail-in ballots. So by requiring DPOC before a voter can even receive a registration form, this executive order directly conflicts with these practices. It goes well beyond what Section 9 of the NVRA currently requires. And again, we talked about last slide, limiting access to the form for eligible voters. So if the EAC, who remember, I mentioned a couple of slides ago, the EAC is in charge of actually writing and creating the National Mail Voter Registration Form. So if the EAC acquiesces to these demands and they implement these DPOC requirements, the mere process of conducting voter registration in Texas would face even more barriers, to reaching voters who rely on federally protected pathways to voter registration. So, you know, there's a huge potential impact for these DPOC requirements, and to be fair, it's many of the same arguments that we heard against SB 16. This would just be done at a federal level as well, so you have an even wider number of voters who could potentially be impacted by these DPOC demands. All right, so we're going to shift gears to a completely different topic. Very, very, very different. And let's talk about another section of the executive order that talks about voting machine certification. So just some background. Texas is one of 11 states, plus the District of Columbia, that require that any voting machines used in their state obtain certification by the EAC. So that is another thing. So the EAC, they are writing the federal voter registration form, but they are also running certification at the federal level of voting machines. So in fact, there's a section of the Texas Election Code. That's a hyperlink if you're ever curious about looking up the language yourself. But a section of the Election Code requires that all voting machines used in Texas be certified by both the EAC and the Secretary of State. So both of the procedures that the EAC and the Secretary of State use, I won't get that far into the weeds for everybody, but just suffice it to say that they are very similar certification processes. They include rigorous testing by multiple experts, and we're talking about months, if not years, of certification testing before a machine is certified for use by either the EAC or the Secretary of State. All of that is to say that, we're not having machines certified and tested in a month or two, right? This is a process that takes months, if not years. All right, so similarly to our section on DPOC, let's look at what the executive order specifically says about voting machine certification. So section 4B1, it demands that the EAC change their current guidelines for certifying voting machines to prohibit the use of any barcode or QR code in the vote counting process. We'll talk about that a little bit in a couple of slides. The other major demand that they're making about voting machine certification is that the executive order demands that by September 25th of this year, so a little over a month from now, the EAC commission review and, if appropriate, that's the language they use, and if appropriate, recertify all voting machines under the new standards that were established in that first section we just talked about. And this is the important part here, and decertify all voting machines that were certified under previous standards, right? So we'll talk about what that would actually do on the ground here in Texas in a couple of slides as well. All right, so I think a quick detour into how Texans cast their ballots is probably helpful here. So you have one of three ways in Texas that people can cast their ballots, right? One is the old school paper ballots. You have a pencil, you have a pen, whatever it is, you mark your paper ballot, you put it in the ballot box, right? Second is what's known as a DRE device, or a direct recording electronic device. These are the machines, the voting machines that use touch screens or buttons to indicate the voter selection. And then the one that's most at risk from this particular executive order and the demands that we'll talk about over the next couple of slides are optical scanners. So this is where voters mark their ballot by hand or by machine, and then the ballot is scanned for tabulation. And so why are these optical scanner machines particularly at risk from this executive order? That's because some scanners use optical character recognition. So that's where the computer program and the scanner, they actually read the individual letters that that are on the ballot or the paper that's being fed into them. However, and most relevant to this executive order, other scanners use a barcode or QR code. So, if after the voter marks their choices on their ballot, the machine will print out a barcode or a QR code, on their ballot, and that QR code or barcode is what's actually read by the scanner, right? So so we can see that's why these optical scanner machines are the ones that are really at risk from this particular executive order. All right, so this is as far in the weeds as I'll drag you, I promise. The EAC, we talked about, one of the demands from the executive order is that the EAC change their voting machine guidelines, right? They change their certification guidelines. Well, those certification guidelines are actually called the Voluntary Voting System Guidelines, or VVSGs. And they are adopted by the EAC, right? They have the sole authority to adopt these voluntary voting system guidelines or to amend existing guidelines. And this was granted to the EAC by HAVA. HAVA, when they created the EAC, gave them the sole authority to create these guidelines. There is a super lengthy and super highly technical process for the adoption or amendment. And importantly, what's really important to us is that the EAC has rules and guidelines and procedures that they've made public that they have to follow in order to actually adopt or amend these voluntary voting system guidelines. And then importantly, anytime a new set of voluntary voting system guidelines is adopted, the rules that the EAC has set up for themselves specifically say that the adoption of a new set of standards doesn't have any impact on the certification status of any previously certified voting machine. So what that means in practice is that once a machine is certified, even if even if these VVSGs change later, it's not going to retroactively decertify a machine that was already certified. Which, if you'll notice, that's exactly what the executive order is demanding that the EAC do. If you really are a glutton for punishment, you can. I provided a link to the most current, what they call life cycle policy, which goes into detail about that technical process for adopting or amending these voting system guidelines. All right, so what about the certification and decertification process at the EAC level? Again, the EAC has been given the sole authority to certify or decertify voting machines at the federal level. President has nothing to do with it. And short of Congress passing another law that challenges that authority or changes the EAC's authority, Congress doesn't have anything to do with it either, right? So again, there is a very formal process for certification, decertification that the EAC has to follow. And I want to point out that the demand that the EAC start this decertification process was just a blanket decertification, right? You notice that's how it was phrased. Problem with that being that by the EAC's own guidelines and procedures, any determination to certify or decertify a voting machine must be individualized. So that means there can't be a blanket certification, can't be a blanket decertification. Every single voting machine has to be judged, tested, approved, certified, or decertified on its own, right? There can't be a blanket, no blanket options there. Again, each voting machine that's submitted undergoes rigorous testing by multiple experts. And here's the other important thing. Voting machines are only decertified if they don't meet the applicable voluntary voting system guidelines. They've been modified or changed without following proper procedures, or the quality, configuration, or compliance of the voting machine is in question.
Hey, Carl, can you just give us a quick side here on the EAC? How do the people get appointed to that? And can the president fire everybody who's on the EAC and appoint his own folks?
Yeah, I'll answer the second question first. Since our Supreme Court is currently going through a period where precedent doesn't really seem to be a constraint, the previous answer would have been no, the EAC is an independent agency, right? So they are set up specifically by HAVA in this case, but they're the statute that created them to be independent of the executive, right? They are appointed by the president. There are 4 commissioners, I believe. And one of the interesting things about the EAC is that the commission is, by law, supposed to have an equal number of Democrats and Republicans on it, right? So what that frequently means is that in practice, the EAC is very frequently just paralyzed from inaction because you'll have the 2 Democrats vote one way and the 2 Republicans vote another way. So yeah, that's how it's supposed to work. Recently, the Supreme Court has been giving the president much more latitude about firing independent federal agency commissioners or chairs. So like I said, the answer to that question, Liz, a couple of months ago would have been different than it is now. So yeah, but yeah, that's the EAC's selection process, I should say. But yeah, they are supposed to be bipartisan by law. Independent agency, again, that means that they're supposed to have independence from the executive agency, from the executive. But
So
yeah, yeah.
are they fully staffed right now? Is it full of,
Well, there are commissioners. The commissioners are full. However, and I didn't go into it because it's extremely in the weeds, but some of the technical committees that they require to adopt these new voluntary voting system guidelines have less than the legally required number of people to form a quorum for any of their business. So the answer to your question is yes and no.
okay, all right, thank you.
Sorry to muddy the waters, but
No, no worries.
but yeah, that's kind of where the EAC and some of their advisory committees sit at this moment. It's a little bit yes and a little bit no on that question. So
Okay, thanks.
yeah, okay. So that's the EAC, right? So let's talk very quickly about the Secretary of State's certification process. So this is the state certification process. So important thing to note here is that before the Secretary of State even begins their certification process, all of these voting machines already have to be certified by the EAC, right? So it's got to be taken care of by the EAC. We've got to be certified by the EAC before the Secretary of State's even going to start looking into it. Um, so how it works here is a little different. We have a team of 4 examiners. 2 are appointed by the Secretary of State and 2 by the Attorney General. They actually lead and conduct the testing of the voting machine itself. They issue a report that either suggests certifying the machine or not certifying the machine. The Secretary of State has to hold a public hearing regarding the application for certification. And then only after that hearing, and that includes notice and comment period as well. But only after that hearing takes place does the Secretary of State make a final determination on whether or not to certify that specific voting machine. So even here, again, you notice that this is done on a voting machine by voting machine basis, right? There's no blanket certification or decertification at either the federal level or here in Texas. So why is this particular demand so potentially impactful for our fellow Texas voters? So we only have 2 manufacturers currently who have voting machines that have been certified by the Secretary of State, and that's ES&S Software, and the other company is Hart InterCivic. So this demand from the executive order particularly impacts ES&S machines, and these are used in about 130 counties for about 7.7 million voters in those counties, which is correct my math, but somewhere around a quarter of the population of our state. And these machines used in these 130 counties utilize one of those barcode scanners that we talked about briefly a few minutes ago. So if thus they wouldn't meet these new requirements that are demanded in the executive order. So again, we have a situation where if the EAC gives into these demands, you have approximately 7.7 million registered voters who, in well over half the counties in our state, would just instantly have their voting machines decertified, less than 2 months before our next statewide election. Remember, we have an election on November 4th, and this decertification, this blanket decertification, is supposed to take place on September 25th. So it's a potentially huge impact for our state if the EAC gives into these demands. All right, and I promise I am almost done talking. We're almost to the question and answer section, but I did want to mention several of the current legal challenges to the executive order. And first, of course, is that the League of Women Voters Education Fund has sued. The main argument there is that they are contending that this executive order unlawfully commands the EAC to adopt voter registration barriers, and they decertify all these state voting machines. Exactly what we've been talking about. And what's important there is that the executive order is trying to override federal and state election laws, which, as we mentioned at the beginning of this presentation, that's not an authority that executive orders, can actually do. And then even further back in the presentation, back to the elections clause, the president doesn't have the authority to make these changes unilaterally. But in the League of Women Voters case as well, the plaintiffs are arguing that these demands also violate the separation of powers by directing an independent agency take actions outside its statutory authority. Remember I said that HAVA had a bunch of requirements, and grants of authority to the EAC. The EAC has to follow the law, that created them. In this case, HAVA. So, but these demands also disrupt the use of the federal form, and would, of course, result in widespread voter disenfranchisement. And lastly, the plaintiffs argue here that the executive order's imposition of a nationwide absentee ballot deadline is an unconstitutional intrusion on state election rules. There are a couple of other cases that I wanted to just briefly mention as well. There's a LULAC case that where the plaintiffs are asserting that the executive order's DPOC requirements impose unjustified burdens on voters. In this case, the LULAC plaintiffs are specifically focusing on students and low-income individuals, and that the directive to the EAC violates federal statutes, including the NVRA, which we mentioned multiple times here, and then importantly, the Administrative Procedure Act. And real quickly, the Administrative Procedure Act, or the APA, is the law that requires federal agencies and federal departments to give public notice, comment, and sets up those rulemaking procedures that we've talked about a few times during this presentation. And also, the LULAC plaintiffs emphasize that the EAC has previously denied similar state requests to add DPOC requirements. Right. So that's actually something that's happened before. States have previously requested that the EAC add DPOC requirements. EAC has told them no. They're arguing that the president can't compel the agency to change the federal form, or importantly, to threaten state funding to achieve those changes. Last case, two more cases. Next to last case that I wanted to briefly mention is the DNC committee, or the DNC versus Trump case. Here, the plaintiffs are arguing that the executive order exceeds the president's constitutional and statutory authority by directing the EAC to impose new voter registration requirements. And in this case, also another provision we didn't talk about this was that the executive order was demanding federal agencies disclose voter information to the EAC, to other branches in the federal government. The DNC plaintiffs are also contending that the executive order unlawfully conditions state compliance with federal funding and alters the federal form without congressional approval. And then lastly, that the executive order also instructs the EAC to recertify state voting systems under standards that are unilaterally set by the president. We went in detail about what those requirements and demands were. And then the DNC plaintiffs are alleging that constitutes an improper executive interference in election administration. Right. So what's the current standing of these cases? All three of those cases are consolidated. So that means they're all being heard together by one judge, Judge Colleen Kohler-Catelli of the U.S. District Court for the District of Columbia. Plaintiffs have sent interrogatories, which are just formal written questions to the Department of Justice, to the Department of Homeland Security, to the EAC, asking them to disclose any communications with state and local officials about the executive order, any implementation of the executive order, and importantly, whether it's already affecting voters in states. I'm sure this is not going to shock anybody on this call, but the administration has refused to respond to any of these interrogatories or formally object to any of these interrogatories. They are claiming that the questions are too broad. They're just too broad for them to answer. In a civil procedure side, the administration is actually past the deadline to formally object to these questions now. So the most recent standing of these cases is that the plaintiffs are now arguing that since the defendants failed to follow the proper discovery rules, the court should compel them to respond because they've waived their right to object. So that's where those consolidated cases, including, of course, the League of Women Voters case, are currently sitting right now. There is one other case that I want to mention, and that's because it has a different focus. So those first three cases, of course, were groups of private citizens who are suing. There's also a case, the state of California versus Trump, that is approaching it from a state authority level. So here, the state of California is arguing that the executive order unlawfully commandeers state authority over elections by requiring these state agencies to verify voter citizenship and implement federal mandates without congressional authorization. Right. So this is again saying that the president can't unilaterally order states to follow these changes. And so this is something that is called the anti-commandeering doctrine. So currently, and again, mentioned briefly that the Supreme Court is being, very, very squirrely when it comes to precedent right now. But current Supreme Court precedent, at least until it's overturned or changed, current Supreme Court precedent states that generally the federal government can't force states to enforce federal laws, right? And that comes out of the 10th Amendment. So that is the main thrust of California's argument here. They also assert that the executive order and the demands violate the Constitution's allocation of power to the states in Congress over election administration. That's that very first section we talked about, state and congressional authority over elections. But it also represents an executive overreach that disrupts states' efforts to conduct elections and protect voter rights in accordance with established law. And so, with that, I did want to say that to any of the attendees who might be fellow members of the legal community, I'm going to leave this slide on the screen for a minute. I was very fortunate enough to get the State Bar of Texas to accredit this for an hour of Texas CLE credit. So, for any lawyers in attendance, fellow members of the legal community, there's the CLE course number for you. So, and with that, I will stop talking for a minute and hand it back over to Liz. Thank you so much, everybody.
Thanks, Carl. That was extremely helpful for us in the league so that we understand what the laws are. And, when we see our commissioners courts doing things like, saying we need to follow the executive order, we can at least make comment that no, the president really does not set the laws in how we conduct elections in Texas.
Yeah. And I wanted to make sure to include resources, whether it's the citing the clause in the election clause in the Constitution or some of those other resources that I scattered throughout the presentation. That way, hopefully they're of use to any of your chapter members who might be facing that same question or similar questions from their commissioners.
Absolutely. One of the questions that came up was about this new comments from Trump just this week about how he wants to get rid of mail-in ballots and voting machines. And I know he has not issued the executive order yet, but can you comment on that?
Yeah, in general terms, because Liz, like you mentioned, there's no text of the executive order that's been issued yet, so we won't be able to dive into the specifics like we were with the order from March. Any attempt by the president to unilaterally make these changes or demand these changes, it's going to run into the same legal hurdles and legal problems that the March executive order does, right? It's again, and those same arguments that we talked about from the league's case, from LULAC's case, from the state of California's case, those are going to come into play if the administration attempts to draft the executive order in the same style that this March order was. So yeah, it's still gonna have the problem that the president doesn't have the legal authority to do this, right? So yeah, unfortunately, since we haven't seen any text from the specific demand that's supposed to be issued, I can't really get into specifics about why, what's wrong about this specific order, or the specific executive order, but I can say that it's still going to run into some of those same very basic, general ground line hurdles that the March executive order has run into as well. So
I know the Secretary of State had a seminar late in July about current election law and what was happening in the state. Did they mention anything about this executive order and give advice to the election administrators during that seminar?
It's a little unclear. We've gotten kind of different reports from different counties. What we can generally piece together is that they at least mentioned it, which that's fair. I think it would be foolish for them not to at least have a discussion or at least mention it. What we're a little bit unclear on is whether they said, counties, you should really start following these requests. You should start planning for these requests now or these demands to be met now, or whether it was like, hey, we want to put this on your radar, make plans or whatever. So we're a little bit unclear about how forceful that statement was, if that answers your question and makes sense, right?
Yeah. And are you aware of any movement that might happen before September 25th? Is the EAC going to issue a statement or to say that they're not going to do anything by September 25th? Or, should we be looking for something or?
Yeah, so there is a technical committee, no, technical development committee group. I'm sorry, it's one of those technical advisory committees that I had mentioned when we were talking about the EAC and the voting system guidelines, right? So buried in the tons of like procedural rules and stuff is that this particular committee has to, has an advisory role. And what that means is that the EAC has them look at these voting system guidelines to determine whether any changes are warranted. And if so, what changes need to be made. So they have been having a series of meetings. They are one of the advisory groups that, at least as of like late July, didn't have a quorum. So there's a real question about whether they can they have the legal authority to even like give their advice to the EAC commissioners. This is really inside baseball here, but they've been having a series of meetings about whether to adopt this new system, voluntary voting system guidelines. Um, I don't see, given the length of the process, previous versions have taken years to adopt, right? And this is being demanded to be done in 6 months. It's really not feasible. But it is one of those situations where they have procedures that are in place that have to be followed. And if they miss any of those procedures, skip any of those procedures, there will be litigation about it. So I am skeptical, and this is my personal opinion. I am skeptical that come September 25th, any of these changes are actually going to be made. They might be made eventually, but I'm skeptical that any of them can actually be made by 5 weeks from now.
Okay. And we have a question from David Smith. Have you looked at HB 37 in the current special session? And does its citation of federal law include the executive order?
I personally am not familiar with HB 37. I
Okay.
can more than happy to look it up. Yeah, I one of my colleagues, Veronica Worms, was supposed to be able to be here tonight. She's actually our legislative expert. However, given the insanity that's happening at the Capitol right now, she was unable to make it tonight. But yeah, I can definitely look at HB 37, and Liz, I can get you an answer to David's question.
Okay, and Elizabeth is telling us that it's been filed, but it hasn't been assigned to a committee yet. So
Okay, so it's real early in the process at this
real
point.
early in the process. Yeah.
Got you.
Yeah.
But no, thank you for the flag, David. Appreciate that.
Yeah. And does anyone else have any other questions? We have about 6 minutes left. This has been really informative and, something that all of us here in all the leagues in Texas have on our radar. And so we will be in Collin County writing up a short statement that we can read to our commissioners court about this webinar, just kind of clarifying the law and talking about some of the things that came out of the EA seminar that happened in July. We want to make sure that our commissioners courts are very aware that we are following this and paying attention. So I know this affects 130 counties in Texas. So if everybody else can just be watching their commissioners court for Collin County and Williamson County, I know that it was on the agenda as renewing a contract for the maintenance on the voting machines. There was no mention of actually voting to move to hand-marked ballots. So we need to be very aware and pay attention of what's going on.
And I will shamelessly pitch TCRP's website. We have a lot of different voter education material and a lot of different election issues. We also have what we've called our local government explainers. And one of them actually goes through in depth about, what exactly the county commissioner's court does. It gives a couple of different avenues for advocacy at the county commissioner's court level. I know that may be not quite as relevant to everybody on this call, but it's also one of those things. If you have friends, colleagues in other organizations or something that may not be as well versed at that county advocacy level, please point them in our direction. Put them in touch with our our advocacy teams, and we're happy to try and help as much as possible. We do really value, and Liz, I know you and I have talked about this. We really do value the partnership between the league and TCRP. It's a wonderful partnership. So love to keep that going however possible.
And I'm going to let you continue to plug. You're going to have a series of other election
We
information.
are. Yeah, so starting September 9th, Tuesday the 9th, Tuesday the 16th, Tuesday the 23rd, and Tuesday the 30th, we're going to be presenting a series of 4-hour-long presentations. We're calling it our 2025 Democracy Deep Dive Series. We're going to talk about voter registration laws. We're going to talk about we're calling one of them all about voting machines. So you'll definitely, if you go to that one, you'll definitely hear more about the machine certification, like we talked about tonight, more in depth about that. We're calling one election resource allocation. If you've ever wondered how are our elections in Texas paid for, how is it determined where polling locations are cited, all of those type of questions. And then because we have a partnership with an organization known as Common Defense, they're a pro-democracy veterans group. We are also putting on a presentation about UOCAVA, so which we talked about briefly tonight. So, Liz, I'll be happy to send you all of those. We're in the process of setting up all the Zoom links and all of that. More than happy to forward those your way when we've got all the tech stuff on our site set up.
Absolutely. I know many of our members would be interested in those. So thank you so
Absolutely.
much, Carl. And thanks everybody for joining. Eileen, thanks for hosting.